If you're navigating the American immigration system, whether as a green card holder, a naturalization applicant, or someone already holding U.S. citizenship, understanding your rights and responsibilities is essential. Today, we're diving deep into a topic that generates considerable anxiety and confusion: the circumstances under which U.S. citizenship can be affected and what the current immigration landscape looks like for those still on their journey. My purpose isn't to create alarm or uncertainty. Rather, it's to provide you with accurate, accessible information that empowers you to make informed decisions. When you truly understand how the system works, you feel more confident, more secure, and better equipped to navigate whatever comes next. Hello, I'm here to help you make sense of the complex world of U.S. immigration. Every single day brings new policy updates, shifting processing timelines, announcements from government agencies, and small but significant details that can impact your case. In this comprehensive discussion, we'll explore the realities of citizenship protection, the exceptional circumstances that might affect it, and the broader immigration updates that matter to applicants, families, professionals, and students worldwide. Before we continue, an important disclaimer: this information is educational in nature and should not be interpreted as legal counsel. I'm not an immigration attorney or government representative. My goal is simply to translate complex immigration concepts into clear, understandable language so you never feel lost or overwhelmed during your journey. Many people operate under the assumption that once you achieve U.S. citizenship, your status becomes absolutely permanent and unchangeable. You receive your naturalization certificate or passport, you register to vote, you settle into your new life, and everything feels secure and final. While this perception contains substantial truth, the complete picture includes some important nuances. American citizenship represents one of the strongest legal statuses in the world, offering extensive protections and rights. However, it exists within a framework of laws, procedures, and oversight systems designed to ensure the integrity of the naturalization process. This doesn't mean government agencies are actively searching for reasons to revoke anyone's citizenship. Instead, it reflects the serious nature of citizenship and the requirement that it be obtained through honest, lawful means from beginning to end. The fundamental truth remains: the overwhelming majority of U.S. citizens, whether naturalized or born in the country, never encounter any challenges to their status. The exceptional cases that occasionally make headlines typically involve extraordinary circumstances such as documented fraud, deliberate deception, or actions fundamentally incompatible with allegiance to the United States. Before examining the rare situations where citizenship might be questioned, let's establish who qualifies as a U.S. citizen. American citizenship is acquired through two primary pathways. The first pathway is citizenship by birth. This category includes individuals born within U.S. territory, born in certain U.S. territories and possessions, or born abroad to at least one American parent who meets specific requirements to transmit citizenship. These individuals are citizens from the moment of birth, regardless of their parents' immigration status in most cases. The second pathway is naturalization. This process applies to foreign nationals who immigrated to the United States, established lawful permanent residence, satisfied residency requirements, demonstrated good moral character, passed English and civics examinations, and ultimately took the oath of allegiance. These individuals earned their citizenship through a comprehensive legal process. Both groups enjoy identical citizenship rights and constitutional protections. Both participate fully in American civic life. However, there exists one meaningful distinction in how the law views their citizenship history, particularly regarding potential challenges to that status. For individuals born as U.S. citizens, their status enjoys extraordinary protection. In virtually all circumstances, birthright citizenship cannot be revoked unless there was significant fraud involving fundamental identity or birth documentation from the very beginning, and such cases are exceptionally rare. For naturalized citizens, there exists a documented record of the entire naturalization journey: applications, interviews, background investigations, supporting documents, and statements made under oath. If government authorities later discover that something critical and material to the naturalization decision was deliberately concealed or falsified, legal mechanisms exist to review that naturalization. This possibility doesn't mean minor errors or honest mistakes jeopardize your status. The focus of such reviews centers on intentional material deception rather than confusion, language barriers, or genuine misunderstandings. The first method by which someone can lose U.S. citizenship surprises many people precisely because it involves absolutely no coercion or government action. We're talking about voluntary renunciation, the formal process by which individuals choose to give up their American citizenship. This isn't something that occurs accidentally or casually. You cannot lose citizenship simply because you expressed frustration with American politics, relocated abroad permanently, or posted on social media that you no longer wish to be American. Renunciation follows a highly structured, formal procedure that must be completed in person at a U.S. embassy or consulate located outside the United States. The process involves meeting with consular officials, completing extensive paperwork, signing formal declarations, and taking an oath in which you explicitly acknowledge that you understand the permanent, irreversible nature of your decision. There's also a substantial administrative fee involved. Once the renunciation process concludes, there's no mechanism to reverse it. You cannot reclaim your citizenship simply because you've had a change of heart. People choose to renounce American citizenship for various personal reasons. Some have permanently settled in another country and wish to fully embrace that nation's citizenship without the complications of dual status. Others are motivated by financial considerations, particularly the unique American requirement that citizens pay U.S. taxes on worldwide income regardless of where they live. Some renounce for deeply personal, political, or identity-related reasons. Whatever motivates the decision, the critical element is that renunciation always represents a voluntary, informed choice. No one is compelled to renounce. When someone completes this process, they forfeit the right to vote in U.S. elections, lose automatic entry privileges to the United States, and will require appropriate visas for any future visits to America. For the vast majority of people, renunciation never becomes a consideration. It remains rare, deliberate, and thoroughly documented. I want to emphasize this point clearly. Simply living abroad, maintaining dual citizenship with another nation, or spending extended periods outside the United States does not automatically endanger your American citizenship. Renunciation occurs only when someone specifically chooses it and completes the formal process. Now we arrive at the topic that generates the most anxiety and uncertainty. Yes, under specific circumstances, the government possesses the authority to revoke citizenship. However, this almost always occurs for one primary reason: serious material fraud during the naturalization process. This procedure is called denaturalization, and it's crucial to understand that it doesn't apply universally. It doesn't happen randomly or arbitrarily. It doesn't occur because someone forgot a specific date on a form years ago or made a minor, inconsequential error during their application. Denaturalization typically occurs when government investigators discover that an individual intentionally concealed something fundamental and material while applying for citizenship. Examples might include using a false identity, hiding a serious criminal history, concealing membership in organizations involved in terrorism or persecution, or providing false testimony about facts central to the naturalization decision. When such evidence comes to light, the matter doesn't get resolved quietly or administratively. Instead, it becomes a formal legal proceeding in federal court. The individual receives official notice of the allegations. They have the right to understand exactly what they're accused of, the right to respond to those accusations, and the right to legal representation. Nothing happens overnight or behind closed doors. The process involves evidence presentation, legal arguments, judicial review, and decisions rendered by federal judges according to established legal standards. I recognize this topic can sound frightening, but here's the essential truth that often gets lost in rumors and speculation. The vast majority of citizens never experience denaturalization proceedings because the vast majority of people navigated their immigration journey honestly and truthfully. Even if English proficiency was limited, even if paperwork seemed confusing, even if unintentional mistakes occurred along the way, the focus of denaturalization cases centers on clear, deliberate material deception, not on misunderstandings or honest errors. Another aspect that surprises many people is the absence of a statutory time limit. The government can potentially review naturalization files years or even decades later if serious evidence of fraud emerges. However, this doesn't mean federal agencies are constantly combing through old files searching for pretexts to strip people of citizenship. Rather, it means citizenship is regarded as something precious and significant, something that must be obtained truthfully. If you followed the required procedures, provided truthful information, submitted accurate documentation, and answered questions honestly during your naturalization process, you typically have no reason for concern. Even when denaturalization cases do proceed, they're not about punishing people who made their best efforts. They're about addressing situations where citizenship was granted based on information that was fundamentally false or misleading. Another area that generates confusion and sometimes unnecessary fear involves the organizations people join and the activities they engage in after becoming U.S. citizens. In highly specific, unusual circumstances, citizenship can be questioned when someone becomes actively involved with organizations that are openly hostile to the United States or that advocate violence against the American government. This isn't about holding political opinions, expressing disagreement with government policies, or engaging in lawful criticism. It isn't about peaceful activism, religious practice, cultural identity, or membership in community organizations. What matters in these exceptional cases is demonstrable intent and active alignment with groups whose stated objectives directly involve overthrowing the U.S. government or causing harm to the nation. Historically, there have been cases where individuals joined designated terrorist organizations, provided material support to hostile foreign governments, or assumed roles that clearly worked against U.S. national security interests. When such situations arise, government authorities may investigate whether the person's original oath of allegiance, the solemn promise made during the naturalization ceremony, was sincere. Sometimes this review occurs within the first several years after naturalization because the law presumes that behavior shortly after obtaining citizenship may reveal the person's true intentions at the time they applied. However, I want to slow down and emphasize something vitally important here. This doesn't apply to ordinary citizens leading normal lives. Living abroad doesn't trigger this. Visiting your country of origin doesn't trigger this. Maintaining strong cultural, familial, or emotional connections to your homeland doesn't trigger this. Even holding firm political opinions or engaging in lawful advocacy doesn't automatically create risk. These exceptional situations involve extreme circumstances, and they're reviewed carefully, deliberately, and through proper legal channels, not through rumors, assumptions, or social media speculation. If you came to the United States with sincere intentions, worked hard, followed established laws, took the oath of allegiance with genuine commitment, and built your life honestly, then you're not the type of person these laws are designed to address. These provisions exist for rare, serious cases involving actual threats to national security, not for everyday citizens pursuing normal lives and contributing to their communities. Whenever you encounter alarming headlines or exaggerated stories, take a moment to breathe and consider context. Ask whether the situation involved violence, deliberate deception, terrorism, or direct harm to the United States. In most cases, understanding the actual facts explains why action was taken. Millions of Americans hold dual citizenship today. Many were born in one country and later naturalized in the United States. Others were born in America to parents from another nation and inherited citizenship from both countries. For the most part, the United States accommodates dual citizenship without imposing automatic penalties or creating inherent risks. You can visit family in your country of origin, maintain your cultural heritage, travel internationally using both passports, and feel connected to both nations simultaneously. This is normal, and for countless families, it represents a meaningful gift that enriches their lives and identities. However, exceptional situations exist where dual citizenship becomes legally complicated. These typically involve accepting formal governmental positions in another country or taking oaths that explicitly reject loyalty to the United States. For instance, if someone assumes a high-ranking official role in a foreign government whose interests conflict with America, or if they sign formal documents declaring exclusive allegiance to another nation, authorities may examine whether they still intend to maintain full commitment to their U.S. citizenship. Even in these circumstances, nothing happens automatically. There's investigation, questioning, and legal analysis. Simply renewing a foreign passport, voting in certain foreign elections, or maintaining family connections typically doesn't threaten American citizenship. The key question centers on intentio. Whether the person meant to formally abandon their American identity through legally significant actions. If you hold dual citizenship, you can breathe easily. For the overwhelming majority of people, it's perfectly acceptable and legal. Travel freely, study, work, care for loved ones, and stay connected to your heritage. The law isn't designed to punish people for honoring their background and maintaining ties to their roots. It's designed to address very specific, rare behaviors that directly contradict the oath taken during naturalization. As always, if anyone faces a complex situation involving dual citizenship and potential conflicts, seeking professional legal guidance provides clarity and peace of mind. Not because you should be afraid, but because accurate information reduces uncertainty. One category that frequently appears in movies, dramatic news coverage, and sensationalized conversations involves losing citizenship due to treason or actions directly against the United States. This represents the most extreme and the rarest possibility of all. In extremely limited cases, individuals can face both criminal prosecution and potential citizenship loss if they actively serve as agents for enemy governments, support armed rebellion against the United States, or commit acts of treason as legally defined. These cases are not commonplace situations. They involve serious federal investigations, substantial evidence, and lengthy legal proceedings conducted in federal courts. Nothing happens quickly, nothing happens secretly. Federal judges must review all evidence thoroughly. The accused individual retains full legal rights throughout the process. The system is designed to be rigorous, careful, and deliberate, with multiple layers of protection against wrongful accusations. For virtually everyone reading this, such scenarios will never come remotely close to your life. Studying abroad, disagreeing with government policies, criticizing political leaders, posting opinions on social media, or experiencing strong emotions about global events does not constitute treason. Everyday concerns, international travel, family visits, and political viewpoints do not lead to citizenship loss. When we discuss treason, we're talking about rare, extraordinary actions with profound legal consequences, and they must be carefully proven according to strict legal standards before any decision affecting citizenship can be made. I share this information not to alarm you, but to provide perspective and remind you that most citizens live their entire lives without the word treason ever being relevant to their circumstances. These laws exist because every sovereign nation must protect itself and its security interests, but they're rarely invoked and they're not designed to target ordinary people simply living their lives, raising families, working, studying, and contributing to society. Let's address another area where rumors often create unnecessary panic: individuals who were born in the United States. If you were born on American soil or in most U.S. territories and received citizenship at birth, your status generally enjoys very strong protection under the Constitution. In nearly every circumstance, your citizenship cannot be taken away simply because you traveled internationally, lived abroad for extended periods, made mistakes, or experienced immigration issues affecting other family members. For U.S.-born citizens, the only exceptionally rare exception involves fraud at the very beginning of life. Situations like falsified birth records, fabricated identities, or organized schemes where documents were intentionally created to fraudulently show a birth in the United States when it didn't actually occur. These situations are extraordinarily difficult to prove. They involve extensive investigations and they usually emerge from large-scale fraud operations rather than from ordinary families. So again, if you were born here, your citizenship is not fragile or precarious. It doesn't disappear because of misunderstandings or because your parents weren't citizens at the time of your birth. Constitutional law is designed to protect people born in the country. When rare fraud cases do arise, they proceed through courts, evidence presentation, appeals, and thorough reviews, not through quick decisions or speculation. I want you to hear this clearly because so many people contact me expressing fear after hearing something online. The truth is that most of the time there's nothing to fear. Awareness serves you well, panic does not. Having covered the exceptional circumstances where citizenship might be questioned, let's shift our attention to something affecting far more people on a daily basis: immigration updates, processing timelines, and the ongoing challenges that families, students, and workers are navigating right now. If you're waiting for a decision on your case, I understand the process can feel frustratingly slow, uncertain, and sometimes unfair. You check your case status repeatedly, you refresh your email constantly, you hear contradictory stories from friends and social media, and it becomes confusing very quickly. That's precisely why I focus on explaining things in straightforward language without panic or hype, just clear information so you understand what to expect. Across numerous categories, USCIS continues working through significant backlogs that accumulated over several years. Some cases are moving faster than applicants anticipated, while others are taking considerably longer than posted processing timelines suggest. For instance, certain employment-based applications and work permits at particular field offices have shown improvement, while family-based petitions in high-volume regions still face substantial delays. This doesn't indicate anything is wrong with your specific case. It typically means the local office is processing thousands of files simultaneously, and each one requires careful verification. When you see cases actively being reviewed in your online status, it often simply means your file is in the queue, not forgotten or lost. When you see no updates for months, that's certainly frustrating, but it remains normal and doesn't signal denial. The most effective approach is to keep your documents well organized, monitor your online account regularly, and respond promptly whenever USCIS requests additional evidence. You don't need to refresh your case status every hour. You don't need to constantly compare your timeline to everyone else's. Each case follows a slightly different path, and silence doesn't automatically indicate bad news. Thank you for trusting me with your time today. I hope this comprehensive information helps you feel more informed, more prepared, and more confident as you continue your immigration journey. Stay hopeful, stay informed, and remember that millions have successfully walked this path before you.